The courtroom had the weight of theater, every breath measured, every glance charged. On one side sat corporate lawyers in $1,000 suits. On the other stood Avery Langston, a 36-year-old black man with clear eyes, steady posture, and a worn legal pad tucked under his arm. Avery wasn't a lawyer in the traditional sense. He was a licensed legal consultant and paralegal, known in Georgia legal circles for his sharp mind and uncanny ability to spot minute details buried in complex legislation. He'd assisted in writing policy memos for nonprofits and even consulted with civil liberties firms. But today, he was defending himself in a civil contract dispute against a powerful property development firm. The opposing counsel, a senior white attorney named Gerald A. Milton III, had made it clear early in the proceedings how he felt. "You might want to think about settling," Milton had sneered outside the courtroom. "We don't want to confuse procedure with passion, son." Avery had smiled, nodded, and walked inside. The case centered around a community land lease that Avery had signed on behalf of a neighborhood collective. The developers were attempting to void the lease, claiming Avery hadn't filed under the proper clause of the Georgia Community Development Code, thus rendering the contract null and unenforceable. They wanted the land for a luxury condo project. In court, Milton strutted confidently through his argument, waving a copy of the code and reading from Section 4.3b. He declared that Avery had cited an outdated and repealed provision, and that his legal filings are therefore irrelevant and invalid. Judge Arlene McMillan raised an eyebrow. "Mr. Langston, do you wish to respond?" Avery stood and walked to the podium calmly. "Yes, Your Honor. I'd like to refer the court to page 412 of the 2024 annotated edition of the same code Mr. Milton is quoting." He held up his copy. He's reading from the 2020 edition. What he fails to mention is that Section 4.3b was amended 2 years ago, and the provision he claims was repealed was actually relocated and expanded under Section 4.3e. The courtroom paused. "Specifically," Avery continued, "my filing cites the amended language that includes the phrase, and I quote, 'collective-based ownership groups acting under municipal charter are exempt from the filing limitation under 4.2a. That's the legal basis for the lease. It's valid." Milton caught mid-smirk, went red in the face. He fumbled through his stack of papers, clearly unaware of the updated statute. Avery wasn't done. He approached the bench, handed a printed legislative update to the judge, and added, "For clarity, Your Honor, this amendment was passed unanimously by the Georgia General Assembly in February 2024. The developer's legal team failed to acknowledge that revision, whether by oversight or design." Judge McMillan flipped through the update, nodded slowly, and turned to Milton. "Counsel, would you care to respond to Mr. Langston's correction?" Milton stammered. "We were under the impression—" "I believe your impression is now incorrect," the judge replied curtly. "Mr. Langston's citation is accurate. The lease is valid and enforceable under current law." She turned back to Avery. "Mr. Langston, this court thanks you for your precision. Motion to void the lease is denied. The case is dismissed in favor of the defendant." The room was silent for a moment before whispers broke out. Avery gave a small nod, packed his notes, and walked out without a word. Outside, a crowd of residents from the neighborhood he'd helped protect greeted him with applause. Some had tears in their eyes. The small community garden, the co-op housing, the mural wall, it all meant something, and now it would stay. A reporter caught up to him. "You beat a high-powered firm with one correction? How?" Avery shrugged. "Law doesn't belong to the privileged. It belongs to those who read it carefully." By that evening, clips of his takedown were trending on social media. "He beat the system with a footnote," read one headline. Civil rights organizations and legal scholars praised the moment as a reminder of why accuracy matters more than arrogance. As for Milton, he issued a quiet apology the next day, but the damage was done. Avery now speaks on legal literacy across the South, encouraging communities to understand the systems meant to protect them and to challenge those who twist them. All it took was one correction, and the truth.